Hi, everyone. Welcome to Coast Legal Aid South Florida's Legal Learning. My name is Lee Solomon. I am a staff attorney here at Coast to Coast in the Family Law Unit, and we are going to review some concepts around child support today. So for today's presentation, we're going to start off with some information about paternity. Then we'll talk about what is child support, how child support is calculated, child support agreements, retroactive child support, Department of Revenue enforcement mechanisms, and frequently asked questions that we get here at Coast to Coast. So before we can start talking about child support, we need to discuss paternity. Florida Statute Section 742 describes all the ways that paternity can be established. Paternity must be established before a child support order can be entered by the court. So there's 5 different ways that paternity can be established. The first way is the marital presumption. What that is if a husband and wife have a child during the marriage, that child is presumed to be the biological and legal child of the husband. The second method for establishing paternity is if the mother and a father have a child that is born out of wedlock, and then they subsequently marry after the child is born, that child is also going to be deemed the child of the husband. The third way is that the parents can sign a voluntary acknowledgement of paternity. This is laid out, the requirements for a voluntary acknowledgement of paternity is laid out in Florida Statute 742.10. This can be signed when the child's born in the hospital, or it can be subsequently signed at a later date. There are very specific requirements surrounding notarization and witnesses that are laid out in the statute. It's important to note that if a voluntary acknowledgement of paternity is signed and neither party does anything to rescind that acknowledgement, then paternity for the child will be established by operation of law. The fourth way paternity is established is by way of a court order. So a court, when presented with a paternity case, can establish paternity based on the admission of the parties. So if both parents appear before the court and admit that the child is theirs and they're waiving any testing for the child, any DNA testing, the court can establish paternity based on the admission of the parties. Another way the court can establish it is by ordering a DNA test, and if the results come back showing that the child belongs to the male, then they can establish paternity in that way. And then finally, paternity can be established by a court by an order of default adjudicating paternity, and we'll talk about that a little more later on. And the fifth way is by way of an administrative order. An administrative law judge can also enter an order establishing paternity by way of DNA testing. So once you have paternity established, you can get a court order establishing child support. Child support is defined in Chapter 61.29, stating that child support is the obligation of both parents to financially support their child. It is a fundamental obligation of the parents to support their child, and it is the child's right to have that support. Neither parent can waive the support for the child. This is something that comes up often in our cases. Parents don't want to have any interaction with the other parent. They're angry and they say, I don't want anything from the mother or from the father, but they cannot waive child support. So now, how is child support calculated? Florida Statute Section 6130 explains exactly how child support is calculated. If you look at the statute, you'll see there's a guideline schedule, which is based on both parents' combined net monthly income. So in order to even find the correct amount of support that's required for the child, you have to make a determination of what the net monthly income is for the parties. And how do we do that? We do that by looking at the gross income of each party and then subtracting from that allowable deductions. Section 6130 lays out what is considered income for purposes of child support and what are the allowable deductions for child support calculations. So in this next slide, you can see here listed all of the different types of income that are to be included for a child support guideline calculation. Salary or wages, bonuses, commissions, allowances, overtime, and tips. This one's very important because a lot of times people think their overtime doesn't get counted, but it does. The statute specifically states it does. Business income from self-employment, partnerships, closed corporations, and independent contracts. Disability benefits. This is, and Social Security benefits, you'll see is listed as well. It includes all disability benefits except for SSI, all workers' compensation benefits and settlements, reemployment assistance or unemployment compensation, pensions, retirements, or annuity payments. As we stated before, Social Security benefits, that's SSD, SSA, SSDI, those are all going to be included as income. Spousal support received from a prior marriage or court ordered in the marriage, interest and dividends, rental income, income from royalties, trusts, or estates, reimbursement expenses or in-kind payments to the extent that they reduce living expenses, gains derived from dealings in property, so long as it is a recurring gain. So that's something to take note of as well. Oh, I think because if it's not recurring, so for example, if somebody is a gambler and they go and they won, you know, a big winning, or they won the lottery, a one-time winning, that's not necessarily going to be considered income because it's not a regular recurring gain. So then after you have a determination of what income is, then you would take away all the deductions that the statute permits. So there's allowable deductions for federal, state, and local income tax deductions, federal insurance contributions or self-employment tax, mandatory union dues, and mandatory retirement payments. They must be mandatory. Health insurance payments. These are health insurance payments for the party, not the health insurance payments that are made on behalf of the child. There's a separate calculation for that in the guideline. So this is just a deduction here is just for the health insurance that the party pays for themselves. Court-ordered support for other children, which is actually paid. This is also something to note here. A lot of times people think just because they have a court order ordering them to pay that they'll get that deduction from their income, but it must be actually paid. The payments have to actually be made. And then spousal support paid pursuant to a court order from a prior marriage or from the marriage that's pending before the court. So once you have your gross income and you take away the allowable deductions, you'd be able to figure out what the net monthly income is for that party. Now, in a situation where you have someone who is not employed, if they are voluntarily unemployed, the court can impute minimum wages to them. They can impute median wages to them or impute based on past earnings. The statute lays out when it is appropriate to do which type of imputation. Generally, median wages is used when a party doesn't participate in the required financial disclosure in a case. And imputing based on past earnings does require proof that they have the present ability to still earn that amount. So a lot of times when someone is temporarily, voluntarily unemployed, the court will just impute minimum wages to them. Another situation is if somebody is disabled. So if a person is disabled and they're deemed not able to work, then income cannot be imputed to them. However, if they are receiving disability income in the form of SSA, Social Security, SSDI, or SSD, veterans disability benefits, private disability insurance, all that can be calculated as income, except for SSI. So when once you have the net monthly income for the parties, the next thing to look at is what's the time sharing arrangement. So there's two types of guidelines that the statute provides for. There's standard guidelines, and then there's gross up shared parental guidelines. So standard guidelines are used when there are less than 20% of overnights spent with the other parent. So 20% of the annual overnights comes out to 73 or more overnights. So if it's less than 73, then you're going to use the standard guideline calculation, and the statute lays out how that's calculated. And if it's more than 20% or more, 73 or more, then you're going to use gross up or shared parental guidelines. So the standard guideline calculation. So how do we figure it out? Once each party's net monthly income is determined, both of the parents' incomes are totaled, and that will allow you to see the total support obligation that is required for that child. Okay. Now, you would take their income and then use the chart, and it will tell you what the amount is, the total support obligation is. Once you have that, if there is a child care or daycare expense, and if there is a health insurance cost for the child, that would be then added on to the support obligation that's listed in the statute. So again, the total support obligation, this is the total amount that both parents are required to provide. It's not broken down into who provides what amount of that total. How do you figure out, though, how much each parent has to pay? You then need to figure out what each parent's percentage share of financial responsibility is for that total obligation. The way you would figure it out is you look at each parent's net monthly income and divide it by the total net monthly income for both parties. So for example, if you have a mother who's earning $2,000 a month and a father who's earning $2,000 a month, their total net monthly income is $4,000. Mom's portion is you're gonna figure it out by doing 2,000 divided by 4,000. That's 0.50, 50%. And so she's responsible for half of that total obligation, total support obligation. And dad would be responsible also for half of the total support obligation. So the other form of gross up guidelines, are called gross up guidelines or shared parental guidelines. They're used when there is substantial time sharing. That is a legal term, again, defined as 20% or more of overnights with the child. It has a different calculation. It does account for the increased expenses that the other parent incurs when they're spending substantial time with the child. They have to provide food and shelter and care for the child when they're spending all that time with them. And so the guidelines are adjusted for that. The amount really varies depending on the incomes of the parties and the number of overnights. Basically, though, in the example that we showed from before, if you have two parents who are earning equal incomes, mom and dad both making $2,000 a month, and they're each spending equal amounts of time with the child, then the child support would be zero. In a scenario where the parent with the majority of the time sharing earns greater income, the amount, if any support is going to be paid, is really going to depend on the exact number of overnights and income. So this calculation, the statute does explain how to do it manually, but it is a little complicated. There's multiplication factors involved. So I would recommend, if you just want to have an idea of how much the support would be, there's several free online calculators. I've here referenced one. FloridaChildSupportCalculator.com. You can put in the information and it'll give you an idea of what the obligation would be. So now let's talk about child support agreements. A lot of times people want to know if they can come to their own agreement for child support. The answer is outside of the court system, parents can agree to an amount of child support to be paid. They don't have to run a guideline. If you and the mom and dad want to just not get the courts involved. They have a child, they want to care for them themselves, and they agree up to a certain amount of support that they're comfortable with, they're free to do so. In those situations, we would always suggest that both parties keep proof of all payments and receipts for purchases. In the event at a later date, it does come to court, you want to have that proof to present as evidence. Now, within the court system, parents can also agree to an amount of child support to be paid by way of a settlement agreement. A lot of times this happens in mediation, sometimes doesn't require mediation. However, either way, within the court system, there must be a child support guideline worksheet attached to the agreement. This is established in Family Law Rule of Procedure 12.285. The requirement to file a guideline worksheet absolutely cannot be waived by the parties. The next topic we're going to talk about is retroactive child support. So retroactive child support is also known as back pay. So sometimes it takes a little while for someone to get to court. And so Florida Statute 6130 provides that in an initial determination of child support, the court has discretion to award retroactive child support to the date when the parents no longer resided together in the same home, but not to exceed a period of 24 months prior to the date of filing of the petition. So sometimes it goes back to when they separated, sometimes it goes back to the date of birth of the child, if they never lived together, but it will never go back further than 24 months prior to the date of filing of a petition for paternity or support or dissolution of marriage, whatever the case is. So the important thing to note, it can only be entered on an initial determination of support. So if support is entered and then 6 years later somebody says, you know what, I never got that back pay, I want it, it's too late. And the retroactive guidelines are based on the party's actual income during the retroactive period. So what the court's going to look at is not what they're earning on the day of the hearing, they're going to look at what they were earning 2 years ago. To calculate what the obligation should have been at that time, and then determine what the amount of back pay is that's owed. The statute provides that the court shall consider, and this is mandatory, they must consider all payments made by a parent to the other parent or the child or third parties for the benefit of the child throughout the proposed retroactive period. So this goes back to that, the importance of keeping receipts and proof of payments. If you have a DOR case, make sure you provide them the copies of the receipts and proof of payments. Keep your originals. And a lot of times people are nervous about the retro because they think it's going to be this huge amount that they're going to have to pay all in one lump sum. However, generally the court does establish installment payment plans. Usually in DOR 4D cases, the payment is set at what 20% of the ongoing obligation is. So if you're ordered to pay $300 a month for ongoing child support and you owe a retroactive balance, what they usually do is require you to pay an additional $60 a month to help pay off that retroactive balance. Once it's paid off, that additional payment would drop. So now DOR cases, the Department of Revenue has all sorts of enforcement mechanisms once they get an order for support that they use in order to enforce it. Florida Statute Section 4092557 allows for the Department of Revenue to use the following enforcement mechanisms: suspending or denying drivers and professional licenses and certificates, fishing and hunting license suspensions, suspending vehicle and vessel registrations, screening applicants for new or renewal licenses, registrations, or certificates, income deduction orders, credit reporting, tax refund intercepts, passport denials, and liens. They have a wide variety of ways of trying to get that support to the parent who's in need. So the most common one that we have people asking us about are the driver's license suspensions. So the way it works there is that If an obligor falls behind on child support, the department's going to send them a notice of delinquency stating the amount of arrears owed and providing them 20 days notice before the driver's license will be suspended. It is really important with all cases, if you have a Department of Revenue case, that you keep your address current with the department. They're going to send this notice of delinquency to your address of record. So if you're no longer living there, you may not receive it if you haven't updated your address. It's critical that you do so. There's also, to be noted, there's a notice of designation of email address form. It is one of the family law forms, and it's form 12.915. So if you're in a situation where you move around a lot and you have a court case, even a regular court case or one involving the Department of Revenue, I would recommend that you use the notice of designation of email address, because then you would be notified through your email, and it won't be such an issue of you not actually getting the communications. So to avoid a suspension of driver's license, you can do a number of things. You can pay whatever the past due amount is. The next thing you can do is contact the department and enter into a payment agreement with them. These are not court-ordered agreements. You will have to sign it, and it'll be on the record for the Department of Revenue, but it will not be filed with the court. They're usually negotiable. It's really negotiable. So if it's worth contacting them, and if you have an amount that you can pay that's not the full arrearage, they may be willing to reinstate your license or stop the suspension if you make that payment. Another thing you can do is, if you are receiving disability, if you're receiving unemployment compensation, TANF, which is cash assistance, if you filed for bankruptcy, these are all circumstances where the department isn't going to suspend your license. So if they're not on notice of this, they may go to attempt to suspend it. But if you notify them otherwise that you are actually, receiving unemployment compensation or disability or cash assistance, they'll put a halt to the suspension. And then the fourth way is you can file a motion to prevent suspension of driver's license for non-payment of support in circuit court and request a hearing on it. So you can ask for a hearing in front of a judge and explain to them, why you haven't been making your payments and why you need your driver's license. And if the court orders that the license be reinstated, then the department is required to reinstate it. Another common issue people have are passport issues. So people a lot of times wonder why the department is how do they have the authority to suspend their passport access? Well, it's Florida statute section 409.2564. It requires the Department of Revenue to certify to the Secretary of the United States Department of Health and Human Services if an obligor owes an arrearage of support in an amount exceeding $2,500. So that's the magic number with passports. If you owe $2,500 or more, chances are your passport's going to be affected. And the best way to resolve this is to pay the arrears. But if you have an urgent need to travel, you can contact the department. If it's work-related travel, you're going to have to provide proof of that. They may consider stopping the halt of the suspension. If you have a close relative's death or medical emergency, if you're an active duty military member, or if you were able to get a court order that requires the reinstatement. However, generally what happens when these cases get to circuit court, the Department of Revenue will argue against the reinstatement, stating that the circuit court doesn't have jurisdiction because it's a federal issue with the passport. So it's not an easy thing to get a court order on it, but the best way is to pay it off. All right, so we have some frequently asked questions here at Coast to Coast. First one is, what happens if you're ordered to pay child support and later become disabled? So if your case is being enforced by the Department of Revenue, I would say that you should contact them immediately to inform them of the disability and send them all your paperwork confirming that you're disabled. You do have the option of filing a supplemental petition for modification of child support, alleging that there's been a substantial change in circumstances. The Department of Revenue might offer to file that on your behalf. So it's something to be noted. You could ask them to review your case and they might file it on your behalf. However, if they're not moving fast enough, you can always file your own modification in circuit court. For a child support modification, you must prove that there's been a change of circumstances that is substantial, involuntary, and permanent. So as far as for substantial, the requirement of that is a monetary requirement with the guidelines. So you would have to prove in a non-DOR 4D case, you would have to prove that the differential, there's a difference between the old calculation amount, the support obligation, and the new support obligation that is greater than 15% or $50. And in the 40 cases, you would have to prove that it is greater than 10% and $25, that monthly difference in the support obligation, to prove that it is a substantial change in circumstances. As far as involuntary, if it's a disability, that is usually involuntary. And then you would have to show that it's a permanent change in circumstance. Case law says it's about 6 months is going to be considered as permanent. Now, if you begin, if you're disabled and you start to receive SSI, support should be suspended immediately. So that's something, if you have a DOR case, you notify them that you're recipient SSI, they should immediately suspend the support obligation. And as we discussed earlier, all other types of disability are considered income. So another question we had here was, how can an unmarried mother request an order for child support when the alleged father refuses to admit paternity and refuses DNA testing? So back to the beginning when we were talking about paternity, and I said you can have a court enter an order establishing paternity by default. That's really what this is about. So in the situation where you are an unmarried mother and you're trying to get an order for child support, you would file a petition to determine paternity and for related relief because you don't have an establishment of paternity. The father must be served with the petition. If he is not served, the court is not going to be able to address child support. If you do not have an address for the alleged father, you may want to contact the Department of Revenue to see if they'll file on your behalf, because the Department of Revenue does have a lot of access to different address location databases. So even though you may not know where he is, they may know where he is, and they may be able to get him served with that petition. And then as part of the petition to determine paternity, you would request that the court order a DNA test. And if you have a hearing and the court will order that DNA test, and the father fails to appear for DNA testing, you can then motion the court to enter a default against the father for failing to appear for that DNA testing, and ask them to adjudicate the paternity based on that default. Sometimes you have a situation where the father answers, files a responsive pleading to that petition, but doesn't show up for that DNA testing. The solution for that would be motioning the court to strike that answer and again asking them to enter that default for paternity. So the key here is really getting him served. If he's served, then you should be able to eventually get an order establishing paternity. So another frequently asked question we have is, can a married mother or father obtain a child support order before a divorce? The simple yes. You would file a petition for support on behalf of the child born in the marriage. There's a form specifically for this, Form 12.904A1, which allows a spouse to petition for child support or alimony. You can do both or just one. However, it's important to note that you can only use this form if there is not a pending dissolution of marriage. And that's all we have for today. I hope this was informative and helpful. And Coast to Coast offers a variety of other legal services. We have a family law unit, a senior and elder law unit, and economic advocacy and community health unit. If you are in need of assistance and you think we can help you, please contact us. And you can see here is our website. All right. Thank you. Have a nice day.